Hey everyone, Harry here to talk about the Supreme Court's unanimous opinion in Trump versus Anderson, reversing the Colorado Supreme Court and its decision barring Donald Trump from the presidential ballot on the ground that he, Trump, had engaged in insurrection after having previously taken an oath and therefore was not qualified to be president under Section 3 of the 14th Amendment. Okay, that's the top line, and no real surprise there. I had attended oral argument and had reported back to you guys that I thought it was clearly going that way, very possibly unanimous. There was some sense that maybe Sotomayor wouldn't get on the train. But she did, but again at the topmost level. So you have a per curiam opinion, and that's an opinion by the whole court for the whole court, as opposed to Chief Justice Roberts delivered the opinion of the court. And a per curiam tends to, I think, give a higher level of unanimity, and it's not just a justice speaking and everyone signs on, but literally it's the court's voice. So that is the sort of top line notion. And in particular, it seemed at oral argument that Justice Kagan and Justice Jackson were going to be good soldiers for the court and say that, that Colorado can't do this. You may remember this provision A came out of nowhere, and then B attracted really strong support from, across the ideological spectrum, saying that it's self-executing. You don't need Congress or anyone else to do it. And it was really very much the sort of constitutional flavor of the month. That month is now finished, as is the application of Section 3, including later in the year, as I'll explain. But okay, so that's the top line. And Chief Justice Roberts, can note with some satisfaction that in a big case, the court speaks with one voice. There's a final paragraph in the opinion, the per curiam part, that says that, and is a sort of feel-good moment. We're all in it together. But they're not all in it together, and just under the surface and not very far, there's actually pretty sharp divisions in the court, and they are over the rationale of the five members in the majority, which comprise here Roberts and Gorsuch, Kavanaugh, Alito, and Thomas. Justice Barrett parts company, as do the three libs. And the basic beef is that the five go farther than is necessary. They don't just say Colorado can't do this. It would create a patchwork solution in the states, and that's just intolerable chaos. I wrote about this at some length. It seemed to be that is what was driving them before, and indeed the majority wrote that and said that's all you need to decide the case. But then they stumbled ahead, and in particular said that you need congressional legislation in order to effectuate it. So that is a really pretty strong constriction of the, not the technical coverage, but the practical application of Section 3, because that's going to be hard to do. You can just think of any situation. What do you need for legislation? Often in this filibuster era, you need 60 on your own side. You need to control possibly both houses, and you need the president not to veto. That's hard to do. Lots of obstacles and impediments. And if you take a step back, it means, this is where we are, in fact, and even in situations in which the provision seems clearly to apply. You have an office holder who swore an oath and then engaged in insurrection. It's going to be a political process that's going to be very, very hard it makes the provision almost a dead letter because it's going to be really hard to get over a filibuster, both houses' signature of the president. But that's what the majority said. You need federal legislation. So Justice Barrett, interestingly, she parts company and just says, I wouldn't have gone that far, but she is very sort of polite, you could say, about it. She says, I don't want to, in a case of this nature, to amplify disagreement with stridency. The important thing is the American people now know what the result is. And by the way, that point really underscores why and when they released it today, March 4th, the day before Super Tuesday and the day before Colorado has its primary. So here they're very concerned about letting people know important information before it's germane when they vote. Not so much, but this is a little aside, in the immunity case where they seem less worried that the American people know whether or not Trump is an adjudicated felon before they vote. All right, but now back to the other three, the Sotomayor, Jackson, and Kagan, and they all make the same point. You did not need to go there, but they're more upset about this, and I think they discern a kind of latent goal of the five to shield Trump. They, specifically this prospect of Trump's winning the election, and they've just said Congress has all the power. But they've gone ahead and said there must be legislation. That ain't happening after the election this year. So basically, they give him an extra sort of safety valve. And the three not only don't like it, they're pretty sharp about it, and no clear indication of sharpness than citing the bête noire opinion. I could say of the left, but really, they're of all sides. It's the real scandalous opinion, perhaps second only to Dred Scott. That is Bush versus Gore. They cite Justice Breyer's dissenting opinion, saying this didn't need to happen and it should have been left undone. That's strong medicine for this sort of case. So that really is kind of taking the court to task. So where are we left? The clear result, as we expected, and the court speaking in one voice, as Roberts would have hoped, and any court institutionalist, and I include Kagan and maybe Jackson after today's opinion there. And yet still a 5-4 result, a sharp political division along political lines, and the five doing, whether this is the reason or not, doing something that really benefits Trump in the upcoming election by taking off the table a power of Congress. After the court said Congress must do this, Congress must do it, they go farther and cite legislation. And by the way, I'm going to go back and look this, but I don't think Congress has always enforced this through legislation. And in particular, in the Jacob Berger, very interesting case post World War I, Congress just by a vote refused to seat him because he was a socialist and considered disloyal. Twice they refused to seat him, and it wasn't by legislation. So, in the Reconstruction period, yes, and they acted by legislation, but I'm not sure that that's the consistent practice all the way through. And this court cares a lot about historical practice and the like. But anyway, the bottom line is clear, and then just under the bottom line, the really strong fracture in this court is also clear. And then, the fact of the matter, were good reasons having nothing to do with Trump, and indeed, it's noteworthy that they go nowhere near Donald Trump. There's no attempt to suggest that he's not an insurrectionist or anything like that. There were good reasons not having to do with Trump to get to this result. There were also very strong textualist, regular legal reasons to find that the text applied, but those really seemed, dead on arrival from way back. Even when the court first took the case, it was my sense they could never ever go that way. But so the result is less of a quibble, but the what the five did, there's just no way around it. It's a extra benefit for Trump, and you combine that with the pretty big shot in the arm they gave him last week in the immunity case, imposing a big delay, even though they're never going to rule for him on the merits, but might give him everything he needs anyway. And it feels as if this court is being fairly involved and interventionist, again, whether it's for the reason or not, of helping out the president who appointed three of them, who I don't think that I think the justices all in all recognize the wickedness of. On the other hand, the partisan Republicans, like many partisan Republicans in the country, might think, yeah, he ain't great, but we don't want Biden. Anyway, you have in the case decided today, Trump versus Anderson, and the cert granted last week, the two biggest election cases in 2024, and both of them so far go, give a little bit of a hand up to Trump, and I think that's how history will record it, even as today's result is on the surface blandly unanimous. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.